Morning. Hi, Sophie. You've asked, is there a minimum age for making a will, or can anyone do it? Anyone can do a will as long as they have assets that need to be dealt with. So it doesn't matter about your age as long as you do have assets that need to be dealt with. You're welcome. I hope you're keeping well. A will lasts forever until you revoke it. You don't have to renew your will. You only have to update or change your will if either your executors change or your beneficiaries change. So a will doesn't need to be changed if, for example, you move address or you change names or your estate assets change. It's only if your executors or beneficiaries change, or if you get married, because marriage does revoke a will. Divorce revokes some aspects of your will. I hope that helps. Morning, Stephanie. How are you? I'm doing some. I hope you're keeping well, Stephanie. Apologies, Stephanie. I'm not sure if you were able to hear my answer in respect of whether a will has to be witnessed by a solicitor. A will can be witnessed by anybody. So this can be a friend or a neighbour, a family member, as long as they are not a beneficiary of the will or a spouse of one of the beneficiaries. So I think at this moment, during these difficult times, we are having some issues in respect of getting wills witnessed, especially with the social distancing rules, but we are trying to take steps to try and overcome this. Ideally, a will should be witnessed by a solicitor, so a solicitor can keep a full file note in respect of the individual's capacity. I hope that helps, Steph. Thank you, Stephanie. Look forward to seeing you soon. All our wills are secured on a fixed fee. A simple will is £250 plus VAT. Simple mirror wills are secured on a fixed fee for £400 plus VAT. So that involves the initial instructions, drafting the will, sending this out to client for their approval, and then a second appointment in order to execute and sign the will. So we do try and ensure that everything is done on a fixed fee to ensure transparency for our clients. Obviously, if you do require a more complicated will, such a discretionary trust will or a right of occupation will or a life interest will, the price does increase, but it is all carried out on a fixed fee. I hope that helps, Ben. You're welcome. Thank you for that question, Ben. I think it is extremely relevant during these difficult times. We have made a decision as of last week that we will not carry out any face-to-face meetings. This is in order, obviously, to assist our vulnerable clients. So we are still taking will appointments, and in fact, we've had quite a rush of people wanting to secure their wills, but all wills are now being taken either by way of telephone instructions or email instructions, and this will be followed up by a physical meeting, hopefully in a few weeks if the government gives us clearance. But I think people are feeling reassured by the fact that they have taken steps to at least put a will in place. So telephone instructions, I can check capacity and I can ensure clients are acting in accordance with the will, the guidelines in terms of being aware of their assets and beneficiaries, and just checking general mental capacity so that they are in a position to put wills in place. And then I am reassuring the clients that hopefully once the wills are ready to be executed, we will attend at their home in order for the wills to be signed. This signing might take place by us actually standing in the garden and witnessing the client signing from an open window, and then signing ourselves in order to maintain the safe social distance. I hope that's helped. Thank you, Stephanie. I do hope that we are providing a service for our clients to give them some reassurance at this time. People are concerned, obviously, about their health, and they wish to make sure that a will is in place so that their children can be adequately provided for and their estate can pass in accordance with their wishes, and also they want to appoint certain people who they trust to administer their estate. So it is a growing concern, especially amongst my elderly clients, but we are trying to meet that need whilst adhering to government guidelines in terms of social distancing. I hope that helped you. Personally, Sophie, in answer to your question about whether we should give copies to wills to anyone, I'm of the view that a will is a confidential document, and as it doesn't really come into play until you pass, you shouldn't really be sharing it, as people have been known to fall out over a will if they're not appointed executors or if they don't receive a share of the estate. So I do advise my clients to not share it with anybody, but of course it's entirely up to individuals if they want to share their will with their children. But we do provide clients with a signed copy to keep at home, and we also ensure that the original is kept in our offices in safe archiving, and we also keep a copy for our file, and we scan a copy onto our system. So there's no real concern about a will going missing, or your children not being, or your family members or beneficiaries not being aware of the existence of a will on your unfortunate passing. I hope that's helped, Sophie. Thank you. Ben, you've asked the question, what is an LPA? An LPA is a lasting power of attorney. It's a court document that gives somebody else authority to deal with your assets, so your property and finance, or your health and welfare, and this is done under two separate legal documents, LPAs, if you lose capacity. So if you lose mental capacity or if you lose physical capacity, you have chosen a certain number of people, maximum of 4, who can essentially step into your shoes and act on your behalf. So, for example, if you unfortunately were diagnosed with dementia, you may want somebody to be able to carry on dealing with your bank accounts, your pensions, the scenario of having to sell your home to pay for care home fees. So it's always a good idea to ensure your LPAs are in place whilst you have capacity, because they cannot be done if cannot be secured if you lose capacity. Some people think the executors in their will be able to deal with their assets if they lose capacity. But what I explain to my clients is a will comes to life on your death. An LPA is for your lifetime. It's to make provisions for you whilst you're alive, but you have lost capacity. So we've touched on property and finances LPAs, which can be used whilst you have capacity or if you lose capacity. So it may be that you physically are no longer able to deal with your bank accounts and you appoint your adult children as your attorneys. This will enable your adult attorneys to go to your bank and register themselves as your legal attorneys, and then they can deal with your banking. With regards to the health and welfare LPA, that can only be used if you have lost capacity, as that allows your attorneys to make decisions about your medical treatment, your personal welfare, so that could be your day-to-day care, make decisions as to where you live, for example, whether you should go into a care home, what care home you should go into, and just to have the ability to make decisions about you personally. So in my opinion, both LPAs are extremely important and they should both be put in place and registered with the Office of the Public Guardian, so that if you in the future require help, you have somebody there, or 2 people at least, who you trust, who you would be happy for them to manage your finances and to manage your personal welfare on your behalf. Again, LPAs is something that we do on a fixed fee, and I do find that a lot of my elderly clients do feel reassured if they have those in place. I hope that helps, Ben. Thank you for your question. There are incentives for combining a will and an LPA. We do offer quite a big discount if people instruct us in respect of both their LPAs. So we offer a £250 discount if someone instructs me for securing their LPAs at the same time. And so we submit the application to the court and do all the signing and witnessing at the same time. So that provides you with a £250 saving. We do try to offer flexibility in terms of costs, but we do believe that amongst our competitors, we offer a reasonable price that reflects the work we do. So fortunately, we haven't had any issues with pricing, but we want to ensure that there is transparency for our clients in terms of our fees. That's a really important question that you've asked in respect of what would happen if you haven't made a will and you pass away. If you haven't made a will, then your estate will pass in accordance with the intestacy rules. Now, these are quite strict rules, which, for example, if you were married, it would allow the first £275,000 of your estate to pass to your spouse. If you don't have a spouse, then it passes to your children. If there are no children, then it may pass to your parents or your siblings or your cousins. So there is a line that is followed in terms of where your estate passes. So sometimes you find that a person who hasn't done a will find that under the intestacy rules, their estate may pass to distant cousins that they've had little contact with during their lifetime, but as they are the only surviving relatives, then it will pass to them. Sometimes, in rare circumstances, if you haven't got a will and you don't have any family members, then your estate may pass to the government, and that isn't necessarily what people would like to happen. Usually people, if they haven't got relatives, make wills in favour of charities, and I think it's better to have a will in place setting out where your assets go to than to allow the intestacy rules to come into play. So it is something I would strongly advise all my clients to consider putting in place. So not only so that their assets pass in accordance with their wishes, but also to ensure that they have somebody they trust or two people they trust to act as executors who are responsible for administering the estate. So that prevents the problem of somebody dying intestate and then no one wanting to apply, or lots of family members then arguing as to who should be applying. So it's always a good idea just to make sure your will is in place. I hope that's answered your question, Sophie. Someone's asked the question as how long I've been practicing for. I've been in the private client department now for 10 years. Every day's different. Every day is interesting. We get to we actually get an insight into people's lives, and we try and ensure that we take a holistic approach to drafting wills. So every family is different. We all have different family dynamics, and we want to make sure that life is easier for clients and their families when they're not here. So I think in 10 years of experience, there's never been 2 days that are the same, because everybody is different, everyone's needs are different. Unfortunately, people do have conflict with family members, people have children they're estranged from. So you want to make sure that people that you should make reasonable provisions for, you do, to prevent a claim against your estate. So I think the first point would be just to ensure that you have a valid will in place. Thank you. Yes, someone who has an LPA, so somebody who is, for example, an attorney under an LPA, they can also be a beneficiary under the same individual's will. So, for example, I've done powers of attorney with my children as my attorneys. They are also the ultimate beneficiaries of my will. There isn't a problem with that at all, because as I explained, your power of attorney is for your lifetime, it ends on your death, a will comes to life on your passing. So I hope that helps you too. In terms of what areas of law I personally cover, I do private client work, which covers wills, LPAs, trusts. Sometimes people put trusts in place for minor children. Sometimes people put trusts in place for vulnerable beneficiaries. So we have to administer the will trusts. Sometimes people put trusts in place for inheritance tax purposes in order to ensure assets pass through the generations. So So yes, I do wills, LPAs, trusts, and I do the administration of estates of deceased people. So that is the bulk of my work. I also do some court protection work for individuals who unfortunately haven't put LPAs in place but have lost mental capacity, and their family members need to access their estates or their assets to pay for care home fees, etc. So we do court protection work. So your question in respect of locations, we are a Kent-based firm, so our services are offered in Orpington, where we are based, and surrounding areas of Orpington. We also have offices in Sevenoaks and in Gravesend. We have satellite offices in King's Cross and in the Shard. We also offer services from our satellite office in Canterbury. So I have clients from as far wide as North London. I have clients down in Canterbury. I have clients in Tunbridge. So really, it's just a case of trying to meet the needs of the clients as and when they are required, but geographically we are based in Kent, and we do service most of London. I hope that helps. If you instructed me this week to do a will, our usual turnaround is 1 week. However, unfortunately, due to at the moment operating with skeleton staff, due to the fears of coronavirus, and also due to the sheer influx of numbers, it is taking about a fortnight to put a will in place. So as soon as I take instructions, I do draft the will and send it out to clients, but then it may not be another few weeks before we can actually meet to execute the will. Of course, where there's no issue in respect of capacity, some people prefer for the will to be sent out to them and for it to be witnessed by friends. It is becoming increasingly difficult to execute a will in view of the fact that we are obviously being advised to maintain social distancing and not have friends or even family members attend at our homes. So it is getting more and more difficult, but we are trying to offer the service of executing a will, albeit we have to maintain that social distance. So it might be a case of us standing, as I say, outside a window and our clients signing the will so that we can witness the signing taking place. So we are trying to do the turnaround as quickly as possible, but I would say a fortnight to perhaps 4 weeks, depending on, as I say, on government guidance. I hope that's helped. Thank you. You've asked the question whether we'd be able to service new wills if there is a full shutdown. Fortunately, we are all set up to work from home, so my phone calls have been diverted to home, so I can take telephone and email instructions and be in a position to draft the wills and send these out to clients for their approval. So we are going to try and operate as usual, because I understand there are a lot of concerns for my clients, who, especially elderly clients, who want to ensure that their wills are put in place. So we're trying to operate a service as normal as possible, albeit it may be from our home premises. But yes, I can continue to take instructions and continue to provide that service. It may be slower than usual, but we will still be able to operate and hopefully be able to assist our clients who are extremely anxious in ensuring their wills and LPAs are in place. You're welcome. I hope you've found that question answer to be informative, and if you do need any further assistance, please feel free to give me a ring. I am available by email and by phone, and we will try and assist. So thank you very much, everyone, for your questions. Take good care of yourselves during this difficult times. Thank you. Bye-bye.